The second of the framework decisions which I'm going to address is the framework decision of 2009, which is entitled Enhancing the Procedural Rights of Persons and Fostering the Application of the Principle of Mutual Recognition to Decisions Rendered in the Absence of the Person Concerned at Trial. And that was made on the 26th of February 2009, and Member States were required to comply with the provisions of the decision by the 28th of March 2011. So what's the framework decision about? Basically, it's looking at the position where trials have taken place in the absence of the person. And this is relatively common in the inquisitorial system. It's less common in the common law jurisdictions, but it's certainly possible and is becoming increasingly frequent. And in a number of framework decisions which deal with other schemes, such as the European Arrest Warrant framework decision, there are grounds to refuse to recognise the decision which has been taken in the absence of the person who's affected by the decision. However, the Commission felt that there was a real inconsistency in the way in which these grounds were being applied, and that there was a need to really sort of standardise the system. So whilst it didn't want to remove the possibility of decisions being not subject to execution because they were taken in the absence of a person, they wanted to try and ensure that there was some consistency as to the way in which executing member states were dealing with this issue. So this framework decision tries to bring this consistency, and it does so by amending all of the other framework decisions which deal with an optional ground for non-recognition of a measure on the grounds that the measure has been taken in the absence of the person concerned. So Article 2 of the framework decision amends the European Arrest Warrant framework decision, and it introduces a new Article 4A. Article 4A still allows for member states to choose not to execute a European arrest warrant on the basis that it was issued following a trial in absence, but it removes the absolute discretion which existed before. So if one of four criteria are made out, then the executing member state cannot refuse to execute the decision simply because the person wasn't present during the trial. The four grounds are that, firstly, the person was either summoned to trial in person, or it's unequivocally established that the person by other means actually received official information about the date and place of trial, and the person was informed that the decision might be handed down if they did not appear for trial. So if that can be shown, then it's not possible for the fact that the person was not present at their trial to form a bar to the execution of the European arrest warrant. The second criteria is that the person was aware of the scheduled trial and had given a mandate to a legal representative to defend themselves at the trial, and was in fact defended by a legal representative at the trial. So again, if the criteria can be shown to exist, and if those were the facts in that case, then it can't be argued that the European arrest warrant should not be given effect to simply because the person wasn't present at their trial. The third criteria is that the requested person was served with the decision, informed of the right to a retrial or an appeal, but they have either expressly stated they did not contest the decision, or did not request a retrial or appeal within the appropriate time frame. The fourth is that the requested person was not personally served with the decision, but will either be served with it after surrender and informed about the right to a retrial or appeal, or will be informed about the time frame within which they must request a retrial or appeal. So if one of these four grounds are made out, then it won't be possible for the person to resist the European arrest warrant on the basis they've been tried in absence. The retrial or the appeal to which the requested person has a right must allow the person to take part in it, and take part in it in an active way. So it must allow for the merits of the case to be re-examined, and it must allow for fresh evidence to be called. It must also be capable of leading to the original decision being reversed. One of the potential issues with this scheme is that it may mean that the person will only have one real chance to defend themselves, because if it's going to be an appeal as opposed to a retrial, then the person will have lost the original opportunity at trial to defend themselves. So that's the amendment which is made by Article 2 to the European Arrest Warrant Framework Decision. Article 3 makes a similar amendment to the framework decision which deals with the mutual recognition of financial penalties, and that the same four grounds essentially are set out and included in the framework decision dealing with the recognition of financial penalties. So Article 4 makes a similar amendment to the framework decision which deals with the mutual recognition of confiscation orders, and it allows for the same 4 criteria to be made out, which will not allow a person to try and argue that a confiscation order shouldn't be given effect to simply because it took place after a process in their absence. Articles 5 and 6 of the framework decision amend the grounds for non-recognition and non-enforcement, respectively in the framework decision of 2008, which deals with the mutual recognition of judgments imposing custodial sentences or other measures which involve the deprivation of liberty, and framework decision 2008, which deals with the mutual recognition of judgments and probation decisions with a view to transferring those probation decisions and alternative sanctions. So similar amendments are made to every framework decision which in fact deals with measures which might have been arrived at following trials in absence, and the aim is to try and standardise the process and to try and make sure that executing member states, if they're applying this bar, are doing so in a way which is consistent, and that issuing member states know what they need to show in order to avoid the bar being successfully invoked.